Welcome to this webinar about mitigating risks at board level. It is a joint webinar between the European Confederation of Directors Associations and the insurance company, the American International Group. I'm Suzanne Liljegren and I will be your moderator during the next hour. Why do European directors have an increased risk of liability today? And what can directors do to protect themselves and reduce the risks? These and many other questions will be answered by our speakers. Their biographies have been sent out to you earlier. Now joining us from Ohio is Mr. Kevin LaCroix. From Paris, we have Ms. Noëlle Lenoir, and from London, Ms. Noona Barlow. Thank you very much for being with us today. I also want to extend a special welcome to all of you who have joined our webinar today. You will be in silent mode, but be aware you are most welcome to put a question or a comment to our speakers. This is how you do it. You move your mouse towards the bottom of your screen and voila, where you see there is a Q&A button that will appear. Now, click on the button, write down your question or comment, and tell me who you want an answer from. I will pick one of your questions after each speaker. Before giving the floor to our first speaker, I want to inform everyone that this webinar is being recorded and will be available through the AIG and ecoDa websites. Now, our first speaker is Mr. Kevin LaCroix. He will give us a perspective of why the risks have increased for European directors, board directors. Now, Kevin, the floor is yours.
Thank you, Suzanne, and good afternoon, everyone. And greetings from Ohio and the Great Lakes region of the United States. I've been involved in directors and officers' liability issues for over 35 years. As an American, most of my experience is in the United States, but I've also been fortunate during especially the last 10 to 15 years to be able to travel around the world and speak to groups like this one about corporate governance issues and directors and officers' liability issues. Often I'm the only American in the room, and I'm very used to hearing in these meetings how suspect the American legal system to others in other countries. And the criticisms of the American litigation system in particular are particularly telling. But I will say one thing that's changed over that time is slowly, there's been an emergence of liability expectations that have created a great deal of commonality around ideas of board responsibility and liability. And I would go so far as to say there is, as is shown on the slide, a convergence around a common set of expectations and a common accountability approach, even if our litigation systems are very different. There are many things I might cite to support this proposition. For example, I might refer to the recent EU directive on collective redress. I might refer to changes in the law as countries as diverse as India or Thailand, the increased regulatory enforcement activity and cross-border collaboration, litigation in countries as diverse as Brazil, Denmark, Japan, and Taiwan. But rather than refer to those many diverse examples, I'm going to refer to two data points. And can we have the next slide, please? As shown in the next slide, here are two recent settlements involving securities litigation in two European countries, resulting in massive settlements. The RBS case in the United Kingdom settled recently for a combined value of 1 billion UK pounds. And the Fortis case in the Netherlands recently settled for 1.3 billion euros. These two settlements are absolutely unprecedented. And if they were in the United States, they would each rank among the top 10 largest settlements in the US. And so what we have is a very different environment where expectations are high and notions of accountability follow corporate activity, regardless of where it takes place. So what are the things that boards should be watching for in light of these changed expectations? In the interest of time, I've reduced my suggestion to three specific topics, which I view as sort of the highest profile examples of emerging liability trends, again, regardless of country. And so the first one, if I may have the next slide, is privacy. I know everyone on this call is very well aware of the General Data Protection Regulation in the EU and the changes that it represents. I want to refer to a couple of examples from the United States to show how changing ideas around privacy have translated into director and officer liability. And before I give those two examples, just to comment a little bit about the fact that, yes, these two examples are from the United States. Because of the size of the US economy, because of its litigation approach, we just have a lot more data. And so there's a lot more meaningful data to analyze and interpret. So yes, these two cases are in the United States, but there's nothing about the circumstances these companies faced that's unique to the United States. The first example is Facebook. Many of you may recall that in July 2018, Facebook released its quarterly earnings report, and the marketplace was disappointed, resulting in the single largest drop in shareholder value of one company in a single day ever, $120 billion drop in market capitalization. The reason for the disappointing earnings release was that Facebook reportedly faced hurdles in implementing its GDPR compliance. And this had resulted in slower growth, which resulted in the stock price drop and resulted in the securities class action lawsuit. Now, you may say Facebook is a distinct company with unique GDPR problems, but it was not the only company to experience this sequence. At about the same time, Nielsen Holdings, the media monitoring company, also reported a disappointing earnings release due to GDPR issues. And again, Nielsen Holdings was then hit with a securities class action lawsuit. In both cases, the company and certain of its directors and officers were named as defendants. I continue to see privacy as an emerging and important issue for all companies and for their boards. If I may have the next slide, I would like to talk about another important emerging issue, and this is climate change. For many years, I've been predicting that there would be directors and officers liability issues about climate change. And for many years, I was wrong because there were no cases revolving around climate change issues. But now there is one very high profile lawsuit in federal court in Texas involving ExxonMobil. The fundamental allegation is that its own internal analysis showed that climate change was likely to affect its ability to be able to monetize its hydrocarbon assets in order to be able to make money drawing oil out of the ground. But the company allegedly failed to disclose its concerns or to modify the asset values on its balance sheet. The company filed a motion to dismiss, and in August of this year, the judge in the case in Texas denied ExxonMobil's motion to dismiss. And then a couple of months later, the New York Attorney General filed a climate change related disclosures civil lawsuit against the company in New York State Court. So this is just one company and it is just one case, and one case doesn't make a trend. But related to the idea of climate change disclosure is climate change affecting company performance. And it's another way that climate change might alter expectations of boards. And the examples I would cite there, cases arising out of the wildfires that recently struck California. In the wake of those wildfires, there have been a number of lawsuits filed against utility companies in California saying that they failed either to take account the risk of wildfires in their operations or failed to warn investors about what might happen to the company's operating performance if there were to be significant wildfires. And that's an example of how evolving climate change circumstances could lead to liability lawsuits against boards and the company officers. There's one further trend I want to touch on briefly. If I may have the next slide. This is potential board liability arising out of the Me Too movement. As you're aware, there have been a number of very high-profile examples of prominent corporate executives who are forced to resign their positions. And in the United States, these have resulted in liability lawsuits. And I've listed a number of them here on the slide. The one I want to particularly emphasize is 21st Century Fox. 21st Century Fox, a media company who had a number of high-profile examples involving media personalities who were accused of sexual misconduct. And this went on over the course of years. An institutional investor filed a shareholder derivative lawsuit against 21st Century Fox's board, resulting in a $90 million settlement, and also the company's adoption of a series of very significant corporate governance reforms to ensure that were there to be any future problems, that the board would take remedial action and protect the company's reputation and operating performance, and to avoid any future problems like the ones that led to the lawsuit. Suzanne, I'm going to stop there and surrender the microphone back to you.
Thank you, Kevin, and thank you for explaining this convergence that we have, or increased in convergence between the responsibilities and liabilities between the US and Europe. Most interesting. I have a question for you first, and that is, do you think that the board directors are aware of these trends today, Kevin?
I do, and it's actually a good question because I do frequently speak to boards. And I've been doing that throughout the course of my career. And through most of the 35 years I've been doing this, the topic of conversation when I met with boards was usually around corporate governance issues or liability issues. And what's changed is in the last 18 to 24 months, the topic of conversation has shifted. It's around cyber liability issues. It's around privacy issues. It's around risk and risk management issues that might cause boards to ask questions about things such as climate change or the Me Too movement. And so I do think there is an awareness, and I do think boards are concerned. They read the headlines along with the rest of us, and they're concerned about not only the risk to the company, but their own personal liability risk as well.
And we will come back to that issue, but we do have a question from our audience, Kevin, that is addressed to you.
Great.
It goes like this. You have identified a number of emerging areas of board liability risks. What steps can boards take to try to avoid potential future litigation, or try to put them in a position to be better able to defend themselves in the event of claims?
It's a great question. Boards appropriately are focused on the company's operating performance and strategic direction. But I think all boards need to recognize that expectations have changed, and with the changing expectations has come increased accountability. So along with the operating performance and strategic direction, boards need to consider the risk environment facing their organization and build board process around risk issues based on an awareness of the risks facing their organization, and acting on that awareness of the risk by asking questions of company management, and where appropriate, consulting or even hiring outside experts. Most importantly, recognizing that in the event of adverse developments, the board's activities will be second-guessed with the benefit of hindsight. So that should guide the board's activities so that they conduct their activities with foresight and an awareness of the possible later scrutiny.
Well, thank you very much, Kevin. Now, let's move on to our next speaker, is Ms. Noëlle Lenoir. She will explain the changing risk environment for European board directors. So Noëlle, please, the floor is yours.
Hello, I'm happy to be there, and I want to thank ecoDa and AIG to invite me for this first experience, because I've never been participating in a webinar before, so I hope it will be okay. Well, I think that the exercise that we are participating in is very illustrative of what has become board members, I speak of individuals, possible liability or at least responsibility it's no longer a national issue, it's an international issue, because most of the companies which have board members involved in all corporate responsibility and operating in different countries, is that they can be subject to law suits in many countries at the same time. Second, I want to stress and to introduce myself very shortly, to say that I've been a judge for the most parts of my career. I've been a minister for Europe, and as you know, the internal market of Europe was built mainly on law, very important, and governance is a great issue at EU level. And now I am a lawyer in the French office of an American law firm in a very calm district today. I want to say that I'm dealing with investigations with GDPR as well. And I want to say that there is now a broader awareness of the individuals. I want to focus not on companies as such, but on board members, individuals, that they can be faced with liability, with lawsuits, personally, individually, and not only the company. Executives, and especially senior executives of companies, are aware of that, because some of them have been put in jail for reasons of corruption, for instance. But it's new, it's a new awareness and worry, of course, of board members. And my idea is to stress the scope of their responsibility and possible liability. What is the possible liability of an independent board member? It can be collective, it is a company, but it can be individual. And there are a number of case law in France, for instance, but in other countries as well, where negligence and not active participation to a wrongful decision have been considered as wrongdoing in itself. Even a board member absent, not present to a board meeting. And there is a big transformation of board members' responsibility, because of course their role is not to manage the company. They have to stick to the role of guidance and control, but they have also to review the internal control mechanisms, and especially take ownership of risk assessment and management. And this role is now increasingly important. Next slide, if you please. Well, I like very much the subtlety of the English language, because you have the notion of responsibility, the notion of accountability. You must prove that you have done right things, but also there is liability, which is of course the last and the ultimate level of responsibility. And to avoid to be subject to a lawsuit, it is absolutely key that board members as individuals have a duty of curiosity, and they have especially to look at the accuracy of the books and records of the company to prevent corruption. That means that they have to be active board members. They have to update their knowledge to fully participate in the board meeting, and especially in the committee's meeting, where is prepared the work of the board. And they have not only to be present, not only to ask questions, but to ask for information and even written documents. And as I said before, they have this role, which is increasingly important, is to closely review risk mapping. It is a legal obligation in France. It is now almost legal obligation in all countries. And they have to have a close look, not only at the financial communications and reporting, but also non-financial reporting and communication, and corporate social responsibility, which is now an integral part of the management of a company. Next slide, if you please. Well, civil liability and even criminal liability may be the next step of future transactions, settlements with companies, and lawsuits which follow these settlements against individual. Why is it that board members will now be more and more often sued for having participated or not impede or prevent wrongdoings or malpractices of the company? First of all, there is the development of a very new kind of liability, which is a vicarious liability. And according to the French duty of care law, for instance, companies have the obligation, and their board as well, to control not only their subsidiaries, but also the suppliers and subcontractors, so to see if they comply with, for instance, AML, anti-money laundering, or with regard to the corporate social responsibility. It's very important that they have a huge overview of the activity of the company in relation with third parties. And of course, as you know, because many things come from the US to Europe, there are more and more often shareholders class action or creditors class action in the event of questionable decision made by the board, which lead to insolvency, for instance. And in that case, what we see at the level of courts is that directors, not to be deemed liable, they have to prove, they have to invoke the lack of information provided to them, so they were not able to prevent malpractices. And it's a very new trend and a very important one. Next slide, if you please. I would focus on anti-corruption and try to do it shortly. This new trend is that negligence is no longer an excuse. So board members, to avoid liability and lawsuits, in case of disclosure of malpractices, they must know that negligence and weak control and not having committed themselves corrupt acts or practices, negligence and weak control may be the source of liability for them. You have the notion in the UK Bribery Act of an offense, which is to fail to prevent bribery, which means they ought to have known and they ought to have acted knowing that there were these kind of practices in the company. You have the notion of willful blindness, which is no longer an excuse under the FCPA, the US anti-corruption law. And also in the French anti-corruption law, the Sapin II law, it is stated that board members have to actively manage corruption risk. That is to say that board members have to be proactive, so to avoid malpractices and to respect and to comply with the social responsibility and the duty not to be corrupt of each company, especially those who operate across the world. Next slide, if you please. So to conclude, what to recommend? First of all, it's not only to the management to look at the practices ongoing in the company, but also to the board. And board members have to set up the proper tone, the famous tone from the top, for the rest of the company to stress that ethics and compliance is part of the performance of the company and not apart from it. Second point, the chief compliance officer of the company, if it exists in rather big companies or middle-sized company, must have direct access to the board. It is too important for the board of directors to know what's going on with regard to updates on compliance requirement, and also the situation of the company in this respect. Do they respect GDPR? Do they respect anti-money laundering law? Do they have put in place internal control mechanisms so to trace financial transaction and to avoid, of course, to give bribes to foreign governments, for instance? Third recommendation, directors should ask and benefit from periodic compliance training based, if possible, on real-life examples. And I think that in this respect, it is not done very often, and it has to be done by companies. And last recommendation, board members must take action when corruption issues bubble up to the surface. And if they don't, they risk to be subject, not perhaps to liability, but to interview, to investigation by the agencies. So if I had to sum up what I say, be a board member, but it is not enough for you to sit on your seat. You have to be proactive.
Thank you, Noëlle. Let me ask you, this is quite known, I think, among most people that this is happening in the US. But do you think that directors in Europe are really aware of these responsibilities?
Well, I won't speak for Europe. I think that in France, they begin to be aware of this because with regard to the agencies in the field of anti-corruption, there is extraterritorial reach. And of course, if they are not sued by their own courts, they begin to be sued by the DOJ or the SFO. And you know, it's a big shock. We have had the main bank, BNP in France, who has had almost $10 billion of fine by the DOJ. So it has been an electroshock. And I think that nowadays they are much more aware, but it's perhaps newer than in the US, even though I think that corruption, unfortunately, is widespread across the world.
Now, if they are getting to become aware of it, do they have the training, enough of training to be able to understand how to deal with it?
No, I think they don't. I think they should have training. It's very rare. I'm a board member and I've not had training in that respect. But I think that it will come, and it will come also with regard to GDPR because the fines could be huge for the company. And as was very rightly said by Kevin, it can destroy not the company, but its dynamism. So I think that they have to be aware vis-à-vis the shareholders, but also the creditors and the employees of their responsibility to take part, not in the management, but in the control of the management in every respect.
Noëlle, we do have some audience questions here. One is, do you think the nomination of a chief ethics officer is necessary?
Yes, I do. I think that you have to have somebody who takes responsibility in this respect and is not apart from the company. Because, of course, in all activities, and the first executive who is concerned is the CFO, the Chief Financial Officer. But I think that the Chief Compliance Officer, the Mr. or Mrs. who is able to say no, is very important. It's a very difficult task, but I plead in favor of the existence of a Chief Compliance Officer, but a Chief Compliance Officer who is really concerned and can explain that business and, how can I say, and ethics is the same. Because especially with global actors such as companies, you know, nowadays nation states are small. You have very big companies. And if the big companies want to be legitimate in a world where, you know, you have, with regard to globalization, many questions now in many countries, and against corruption as well, it endangers democracy, and the big companies have a duty of exemplarity, in my view. So they have to have somebody who takes in charge this issue.
Well, thank you very much. I think that we do have, as a matter of fact, time for one more question from the audience. And this one is coming, saying like this: given the increasing performance expectations on board directors, and their increase in exposure to lawsuits and loss of reputation, is there a danger that smart and experienced people consider the risk-reward, let me see here, what we say, risk-reward?
Well, of course, you can say the same thing.
That they're afraid of taking on this responsibility, is what they were saying.
Well, it's the same for politicians, you know, it's a great responsibility. I think that if the people are really expert, are really engaged, it's an amazing mission. It's an amazing mission because, of course, you have a great responsibility. But I wonder whether it cannot be a way of selecting people who are prepared to take this responsibility. There will be less numerous, of course, because people are really scared by lawsuits and especially class actions. But I think that it is you will find very top people accepting that. To be a CEO is also very dangerous today. To be a CFO is also very dangerous. Not speaking, of course, of politicians as such, it's very dangerous where you are honest, because but I think that it is necessary to train people and young people to this responsibility and to their duty, because we have to have an ideal, and this ideal must be we take in charge economic responsibility and at the same time ensure that these activities are clean and comply with ethics. So I think we'll find people, women and men.
No, thank you so much, Noëlle, for making us European directors better aware of the risk environment we are facing and the scope of our responsibilities. And I think there's one more comment here from one of the in the audience saying that the remuneration of non-executive directors is far below that of CEO and CFO. So that is also a problem. But I think that before we move to our next and last speaker, I think it's time for all of you in the audience to interact with our speakers. And we would do that through a poll. We want to know what the main concern is in your boardroom today. What risks are you discussing in your boardroom? What is your board worried about? So now we will launch the poll, and I hope that we will see that on your screen. Here we go. So, in other words, what is the most concern in your boardroom? Is it privacy, that Kevin talked about, data security, Me Too sexual misconduct, Kevin brought that up too, or is it corruption, bribery? Is it competition, antitrust issues? Is it climate change or health and safety issues? Please fill it out now. Click on the one most important risk that your board is concerned about today. And after the next speaker, we will have the results from you. Now, moving to our last speaker, it is Ms. Noona Barlow. She will give you the reality of today's claim. What are they? How much money are we talking about? And how to protect yourself as board director. Noona, the floor is yours.
Thank you very much, Suzanne. Could I see the slides, please? The first slide. Yeah, the next one. Thank you. So I wanted to thank Kevin and Noëlle, because they have very nicely set up a lot of the topics that I'm going to cover today. Obviously, my interest is very specifically D&O claims, so I wanted to highlight for you some of the particular issues that we're seeing in the D&O claims environment. A lot of, as Kevin suggested, a lot of the examples that we see are still from the US, but we are seeing increasing activity in the UK and Europe. So this first slide shows you the sources of claims against directors that we're currently seeing. And as many of you know, that D&O insurance has been around for quite some time, and historically I think most of the claims were US securities class actions. But since the institution of D&O insurance, claims have evolved significantly, particularly since the global financial crisis. And I think it was Noëlle who highlighted the issue that we're now much more focused on the activities and the accountability and responsibility of individual directors. Whereas in the past, pre-financial crisis, there was a lot of focus on the company and what the company has done. Post-financial crisis, I think there was very much a sense that individuals, those people who are making bad decisions, those people who are making wrong decisions, actually have to be held to account. So as I say, we're now seeing more and more activity focused on individual accountability. And from a UK and European perspective, that's being manifested through regulatory investigations and increased regulatory scrutiny of directors, both in the form of investigations of market activity, but also criminal investigations. And I think from a claims perspective, what we're seeing is that criminal investigations more often than not relate to bribery and corruption, which continues to be a significant issue around the world. Can I have the next slide, please? So we did a review of how much claims cost, how much particular types of claims cost. And this is on our commercial D&O claims for 2 years, May 2016 to May 2018. And what you can see from the slide is that US securities class actions continue to be the most expensive types of claims that we deal with, along with US regulatory investigations. But if you look on the bottom half of the slide, what you'll see is we're spending a lot of money on non-US activities. Excuse me, so non-US securities claims, non-US regulatory investigations, such as the Serious Fraud Office or the Financial Conduct Authority here in the UK. And as I say, we're spending a lot of money on bribery and corruption investigations. If there was one thing that I expect to see areas of increasing costs, it's definitely in the area of bribery and corruption. One of the other things that we've done this year is a review of our very largest case reserves that we're holding with respect to claims. And 40% of the claims with the highest reserves relate to bribery and corruption investigations around the world. Another area that continues to be a significant issue for us, primarily in Europe, much more so than the UK, is the issue of insolvencies. Most of these claims against directors are brought by the bankruptcy trustee, and the claims relate to actions by the insured pre-insolvency, particularly in that window where the company should have been declared insolvent. These are often very large and very complex claims with a number of parties. And we're also seeing in many countries the same trustees, the same administrators coming up over and over again and bringing claims. So they're developing reputations within their particular countries for bringing claims. The allegations are usually management fraud or breaches of duty, and almost always involve trading in that period of time where the company should have been declared insolvent. Could I have the next slide, please? So there are a number of areas of concern for us from a claims perspective. And first and foremost, the thing that we're worried about is defense costs. So a D&O policy obviously provides two relevant services for the benefit of a director. Defense costs for the director, which is really the value, I think that the key value of the policy is that a director is able to defend him or herself against any claims brought against them. And the other part is obviously if there's a contribution to settlement or that kind of thing. In the UK and Europe, the bulk of the money, the insurance money that we spend on D&O is for defense costs. And as I say, of concern is that those costs are really going up. We've now seen firms in the US who are charging $1,500 per hour for their partner rates. And as a result, and in the UK, we're also seeing regulatory investigations, for instance, Serious Fraud Office investigations, which is often involved in the bribery and corruption investigations. Those investigations are now costing millions of pounds per director. So sometimes as much as between £4 and £6 million per director. And so as a result, we're seeing an increase in the severity of our claims. So we can spend an entire primary insurance limit on defense costs. And in cases where we only participate on excess layers within a tower of insurance, we're now seeing costs incurred on those layers, whereas historically we would not have expected to spend money at that level. Some of the other things that we're watching are the claims, US securities claims against foreign companies. So following a decision from many years ago called Morrison versus National Australia Bank, we saw a real drop off in claims against foreign companies. But recently there's been a decision called Toshiba, which is having the effect and potentially will have the effect of seeing non-US firms drawn back into US securities litigation, which obviously for us is concerning in part because of the costs of those claims. And then insolvency continues to be one of the most significant drivers of claims in Europe. You'll also see on there deferred prosecution agreements. More and more companies are signing these deferred prosecution agreements, and what usually happens is once that agreement is signed, litigation then often follows against the company. Could I have the next slide, please? So this is the final slide, and you'll see my comments are very similar to the comments that Kevin had addressed, and the areas of concern from a European claims perspective are very much the issues that are impacting Kevin in the US as well. So just to talk about a couple of things that Kevin didn't reference, first of all, cyber breaches. We have started to see successful derivative actions and securities class actions against directors following cyber breaches. There are a couple of claims, noteworthy claims in the US, Yahoo and Equifax. Yahoo settled for $80 million and was fined $35 million by the SEC for failing to disclose the breaches in a timely fashion. You may also have seen in the news that very recently the hotel chain Marriott, its subsidiary or franchise Starwood, is subject to a data breach that has apparently been going on since 2014, so for more than 4 years. And the hackers have been able to access the guests' personal data, such as addresses, email addresses, dates of birth, passports of hundreds of millions of guests. And so that was disclosed by Marriott on the 30th of November, and on the 1st of December, so the next day, a securities class action was filed against Marriott, against the CFO, the CEO, and others, in which it is alleged that Marriott's statements in its SEC filings in the US were misleading with respect to the importance of information technology security. In the UK, we've recently seen a number of very high-profile cyber breaches or system failures, and although to date we've seen no specific claims against directors following those breaches, we have one instance in which the Financial Conduct Authority, which is the UK regulator obviously, is investigating following the system failure. And we expect that one of these events will give rise to further activity against the board and against directors. From a health and safety perspective, a couple of claims examples. So there's a securities class action in the US against Arconic, which is the manufacturer that manufactured the cladding panels that were used on Grenfell Tower, which is the high-rise apartment block that caught fire in London and in July of 2017 and resulted in numerous deaths. And the lawsuit alleges that Arconic failed to properly disclose the sale of highly flammable materials. One of the claims that we're dealing with here in the UK is for one of our insureds that manufactures consumer products, and its directors are being investigated by several of the regulators in South Korea, arising from allegations that one of the insured's products is potentially dangerous and could cause serious lung damage. There are allegations that the insured had violated local labeling and advertising law, and those investigations in South Korea have cost us about £10 million in defense costs for these directors. So obviously, Kevin addressed the issue of climate change and GDPR. And I think following on the fact that we have now seen some fines implemented under GDPR, as far as I know, one in Austria, one in Portugal, and one in Germany, still quite moderate fines. But I think as soon as we start to see an increased level of activity and fines being imposed, we will see that resonate in the boardroom as well. And so just in conclusion, I think the theme that you've probably heard from all of us who are speaking to you today is that we're seeing a definite change in the risk landscape for directors. And there is an absolute need for boards to recognize and prepare for that change. So whereas, issues like accounting issues and financial disclosure issues used to be the significant ones, boards are now having to deal with issues such as corporate social responsibility and environmental issues. The threats, as Noëlle said, need to be taken very seriously, and the changes have to be implemented from the top. So the culture change, any activity that's going to change within the organization has to come from the top down. And companies probably need to consider different ways of working and also the possibility of changing the dynamic of their boards. So they having board members with different knowledge and different expertise and experience to reflect the changing environment. So I'll hand the mic back to you, Suzanne.
Thank you very much, Noona. I must say, when I hear all of this, I think for us in Europe that we have not had that kind of history as you have had in the US. It comes to my mind, is this a development inevitable, or can something be done?
I think it is. I think it is unfortunately inevitable. And within my remit, we deal with a lot of claims across Europe as well. And we are seeing, as I say, insolvency claims, bribery and corruption claims, issues of social responsibility, things such as Me Too in boards across Europe as well. So it is an inevitable change. And as I say, the important thing is that boards adapt to that change and are able to manage the different environment that we're living in now.
Well, I think that we have several questions from the audience for you too, Noona, but I want to start with one because our audience is also concerned, just as you are, about the risk at board level, and they want to know what keeps you up at night regarding directors and officers' insurance claims.
Well, I think probably everything that we've talked about today, but I think probably the hottest topic for me right now is this issue of defense costs. We've had a recent example, and as I say, if the cost of regulatory investigations are going up and up, we are also seeing, unfortunately, I think sometimes lawyers taking advantage of the fact that there is an insurance policy responding, and sometimes the quotations that we get for costs to defend directors are extraordinary and very unreasonable and risk the policy limits being spent on one director. And so I think as, for all of us, it's incumbent on us, both directors, companies, and insurance companies, to ensure that we're getting the absolute best value from defense costs. Because as I say, that's sort of the key aspect of a D&O policy for a board member, for a director, is that ability to fight claims, because not all claims that are brought against directors are good claims. They may sometimes, a director may be sued or investigated as a spurious claim or without basis. So having the ability to defend oneself is really, really important.
It comes to my mind, is it a kind of a new industry coming up here? People are doing claims? Class action?
It's probably not a new industry for Kevin, but I think more and more in Europe it is becoming a bit of an industry for some law firms.
We do have a comment here for you also from the audience, Noona. It's Alex that says, looks like independent directors are more concerned about their personal litigations and not shareholders' interests. What about that?
I'm not sure I understand the question or the comment.
That we are protecting ourselves, the directors, and not concerned about the bribery, corruption that is affecting, for instance, the shareholders. I think that's what.
Yeah, and I suppose the reality is there are sort of what we call black hat directors, so directors who are guilty of wrongdoing. But I do think the vast majority of directors are and non-execs are out there trying to do the best they can in what is a very, very difficult environment.
Okay, thank you very much, Noona. Now we are having a results from our poll. And Georgie, I think maybe you can have it on the screen. Let's see now, what is the most concern in your boardroom out there? It's data security, it looks like. 69% of you have said that data security is the biggest concern in your boardroom. And what about health and safety issues that Noona brought up? That was just 9%. And nothing on Me Too sexual misconduct. Okay, Kevin, what is your take on this result?
Well, it's interesting. Obviously, what jumps out at you is more than 2/3 of the people that responded said data security issues are the most important. And that's consistent with what I've seen when I've talked to boards. It is a primary concern for boards everywhere. Obviously, my experience is focused on the US, but it doesn't surprise me at all that directors in Europe are concerned about this as well. And actually, if you lump in privacy together with data security, I think you'll see that it's a predominant issue and of greatest concern to boards. I'm a little surprised that the Me Too sexual misconduct didn't get any votes. And part of the reason I say that, I think workplace management issues are obviously critically important. And I don't think it should be overlooked that there are very real concerns for companies and their boards to be thinking about it in terms of gender equity issues, gender pay issues. And so I hope that doesn't mean that that's an issue that isn't on the radar screen for boards, because I do think it's going to continue to be an important issue and one that is going to affect quite a number of companies throughout the world, in Europe as well. You know, when Noëlle was speaking, I found myself reflecting on how important awareness of corruption and bribery issues is for any company, regardless of where they're based, regardless of where they're doing business. So again, that's another important issue that I hope boards are keeping very close to the center of their radar screens.
So basically what you're saying here, the corruption bribery is only 25%. Is this like a signal for European directors that, hey, you are not paying enough attention here?
Well, people only got to vote for one. So, you know, I don't think we can infer that corruption and bribery is not an important issue. It's just that for only a quarter of the people was it the most important issue. But you know, what might be interesting if we could have a poll where the various choices were weighted to see where say corruption and bribery falls with respect to the other issues.
Thank you very much, Kevin. Let's move on to you, Noëlle. Are you surprised by these results?
Well, I'm not surprised. I have two observations. The first one is that I think that the question of privacy and data security is a bit misleading, because you have data security, so violation of personal data, it has to do with privacy, and data security is cyber attack against the activity of the company. So it's a bit misleading. People are not so much interested in privacy, and I'm a bit astonished. And data security, everyone knows that the big danger now is breach of data security, even for our security as citizens. As you know, in most of the countries, you have a fourth army, which is cyber. And in the US, in France, we have a general at the head of cyber, because it's really one of the main dangers for companies and for countries. And I think that board members are aware, and more companies are recruiting a head of security. And it's key, because if you are not sure, and you have seen the issue with Huawei, for instance, it's a big issue, you know, throughout the world. So I think that I understand the answer. I think that privacy is a bit misleading. With regard to Me Too, as a woman, of course, I'm astonished, but I think once again that perhaps this question is a bit different from the others, because it's not, you know, the board members, they have as such look at health and safety issue for employees, climate change, competition, corruption, data security, but they are concerned by Me Too. They are not the head of human resource, you know. It's only if the company does nothing, but it's more a solely individual issue than the task of the company, you know, as such. So you have also the company has to look at the people who take drugs or things. So I think that the question is a bit misleading. I'm a bit concerned with regard to corruption, as Kevin said, and Noona as well, because competition is considered as behind us, because we have now agencies, we have had so many fines inflicted for cartels to company, and now the company are so worried, so scared of being sued for this, with the big hand of the US authorities and of the EU Commission, that they are aware of the dangers, and I think that they are much more cautious in this respect. With regard to corruption, I'm a bit astonished, 25% is not at all enough. It's a big issue. It can destroy a company, and it destroy the belief in the in the company itself. And it's so I think it's not enough, in my view.
Thank you, Noëlle. Noona, what is your reaction when you see the concerns of boards of the audience?
Very similar to Kevin and Noëlle. The only thing I would add about the Me Too sexual misconduct is there is a view that the reason that boards aren't concerned about it is because oftentimes, unless it's a huge problem within the company, these issues just never make it to the board because they're dealt with, as Noëlle said, within the human resources department. I think the problem from a board perspective is just because you don't know about it, you can't assume that it's not an issue and it's not a problem that needs to be dealt with. You know, if people are being hushed up or signing confidentiality agreements or being paid off to leave the company, that's a significant problem that needs to be addressed. So I think it's important that companies don't assume that a lack of knowledge high up in the organization means that it isn't a problem. It is something that the board should provide itself comfort with, that, you know, gender pay issues and Me Too issues are all being dealt with appropriately. But as I think Kevin's point is probably the right one, people only got to pick one, and it doesn't surprise me at all. And I think it's absolutely appropriate that data security is the top of everyone's concern, because the reality is, I think we're all of the view that from an organizational perspective, it's not if they have a cyber breach, it's when they have a cyber breach and what they do to prepare themselves for it and how they respond if a breach occurs.
Yeah. Now, of course, you are dealing with the results of people not being aware of these risks. So what would you say now when considering that you don't want to have claims, unnecessary claims that you have to deal with? So what would you say about this? What is the area where you think that the directors must focus more on? Is it corruption, bribery, like Noëlle's saying, or is it something else?
I think I do think it is it has to be all of those things, and a good board has to be able to address all of those issues. And as I say, you know, make sure that they are setting the right culture, because if you set the right culture, issues like Me Too and corruption and bribery could arguably be dealt with, at least in part, that way. I think data security has to be the biggest issue because it probably poses the greatest potential risk these days. And, you know, when we deal with companies who've had cyber breaches, they fall into two neat groups. One group who is very well prepared and deal with these breaches very effectively, and the other group who are not prepared and do not deal with them effectively. And you'd much rather be in the first group than in the second group.
Sounds very wise. Thank you, Noona, Noëlle, and Kevin, for providing us with your expertise. After this webinar, I think we as board directors are much better prepared to mitigate the risks at board level. And that is a good thing, I think, for us in Europe. Our hour is up, and we will shortly close this webinar. But before we end, I want to inform our audience that you will all receive the slides of the speakers by email. So thank you all for participating in this joint ecoDa AIG webinar, and goodbye.
Thank you.
Goodbye.
All right, thank you.
Thank
Goodbye.
you.
Bye.